In law, statelessness is the lack of citizenship and/or nationality, or the absence of a recognized link between an individual and any state. A stateless person is someone who is not considered as a national by any state under the operation of its law. He or she has no citizenship or nationality. Some stateless persons are also refugees. However, not all refugees are stateless, and many persons who are stateless have never crossed an international border. Causes of statelessness. Conflict of law. Conflicting nationality laws are one of numerous causes of statelessness. Nationality is usually acquired through one of two modes. Jus soli denotes a regime by which nationality is acquired through birth on the territory of the state. This is common in the Americas. Jus sanguinis is a regime by which nationality is acquired through descent, usually from a parent who is a national. Today, many nations apply a combination of the two systems. Gender discrimination. Although many states allow the acquisition of nationality through parental descent irrespective of where the child is born, many do not allow female citizens to confer nationality to the children. There are 27 countries in the world that do not grant equal rights to women in passing on the nationality. This can result in statelessness when the father is stateless, unknown, or otherwise unable to confer nationality. There have, however, been recent changes in favor of gender neutrality in nationality laws, including successful reform processes in Algeria, Morocco, and Senegal that may inform change elsewhere. For example, Algeria amended its nationality code to repeal the limitations on mothers' ability to confer nationality on the children, replacing them with an overarching provision granting Algerian nationality to all children born in or outside Algeria to an Algerian mother or father. Moreover, the Convention on the Elimination of All Forms of Discrimination Against Women prohibits sex-based discrimination in the conferral of nationality, and an important measure to prevent statelessness at birth provides nationality to children born in a territory who would otherwise be stateless. This norm is stipulated in the 1961 Convention on the Reduction of Statelessness, appears in several regional human rights treaties, including the American Convention on Human Rights, the European Convention on Nationality, and the African Charter on the Rights and Welfare of the Child, and is implicit in the United Nations Convention on the Rights of the Child. Discrimination in most large-scale statelessness situations. Statelessness is a result of discrimination. Many states define the body of citizens based on ethnicity, leading to the exclusion of large groups. This violates international laws against discrimination. The United Nations Committee on the Elimination of Racial Discrimination stated on 1 October 2014 that the deprivation of citizenship on the basis of race, color, descent, or national or ethnic origin is a breach of states' obligations to ensure non-discriminatory enjoyment of the right to nationality. State succession. In some cases, statelessness is a consequence of state succession. Some people become stateless when the state of nationality ceases to exist, or when the territory on which they live comes under the control of another state. This was the case when the Soviet Union disintegrated, and also in the cases of Yugoslavia and Ethiopia. Administrative obstacles. People may also become stateless as a result of administrative and practical problems, especially when they're from a group whose nationality is questioned. Individuals might be entitled to citizenship but unable to undertake the necessary procedural steps. They may be required to pay excessive fees for documentation proving nationality, to provide documentation that is not available to them, or to meet unrealistic deadlines, or they may face geographic illiteracy barriers. In disruptive conflict or post-conflict situations, many people find that difficult difficulties in completing simple administrative procedures are exacerbated. Such obstacles may affect the ability of individuals to complete procedures such as birth registration, fundamental to the prevention of statelessness in children. Whilst birth registration alone does not confer citizenship on a child, the documentation of place of birth and parentage is instrumental in proving the link between an individual and a state for the acquisition of nationality. The United Nations Children's Fund estimated in 2013 that 230 million children under the age of 5 have not been registered. Not holding proof of nationality, being undocumented, is not the same as being stateless, but the lack of identity documents such as a birth certificate can lead to statelessness. Many millions of people live their entire lives without documents, without the nationality ever being questioned. Two factors are of particular importance: whether the nationality in question was acquired automatically or through some form of registration, whether the person has ever been denied documents on the basis that he or she is not a national. If nationality is acquired automatically, the person is a national regardless of documentation status. If registration is required, then the person is not a national until the process has been completed. As a practical matter, the longer a person is undocumented, the greater the likelihood that he or she will end up in a situation where no state recognizes him or her as a national. Renunciation: in rare cases, individuals may become stateless upon renouncing the citizenship. People who subscribe to voluntarist, agrist, or some other philosophical, political, or religious beliefs may desire or seek statelessness. Many states do not allow citizens to renounce the nationality unless they acquire another. However, consular officials are unlikely to be familiar with the citizenship laws of all countries, so there may still be situations where renunciation leads to effective statelessness. Non-state territories. A final cause of statelessness is non-state territories. As per the definition of a stateless person, only states can have nationals. As a result, people who are citizens of non-state territories are stateless. This includes, for instance, residents of occupied territories where statehood has ceased to exist and never emerged in the first place. The Palestinian territories are the most prominent example. Others are Western Sahara and Northern Cyprus. While statelessness has existed for several centuries, the international community has only been concerned with its eradication since the middle of the 20th century. In 1954, the United Nations adopted the Convention relating to the status of stateless persons, which provides a framework for the protection of the stateless. 7 years later, the United Nations adopted the Convention on the Reduction of Statelessness. In addition, a range of regional and international human rights treaties guarantee a right to nationality, with special protections for certain groups, including stateless persons. States bound by the 1989 Convention on the Rights of the Child are obligated to ensure that every child acquires a nationality. The Convention requires states to implement this provision in particular where the child would otherwise be stateless, and in a manner that is in the best interests of the child. The status of a person who might be stateless ultimately depends on the viewpoint of the state with respect to the individual or a group of people. In some cases, the state makes its view clear and explicit. In others, its viewpoint is hard to discern. In those cases, one may need to rely on prima facie evidence of the view of the state, which in turn may give rise to a presumption of statelessness. History. Before World War II, the status of slaves and inhabitants of conquered territories in the Greco-Roman world of antiquity is in some ways analogous to contemporary statelessness. In antiquity, statelessness affected captive and subject populations denied full citizenship, including those enslaved. Some characteristics of statelessness could be observed among apostates and slaves in Islamic society. Statelessness also used to characterize the Romani people, whose traditional nomadic lifestyles meant that they traveled across lands claimed by others. The Nansen International Office for Refugees was an international organization of the League of Nations in charge of refugees from 1930 to 1939. It received the Nobel Peace Prize in 1938. Nansen passports, designed in 1922 by founder Fridtjof Nansen, were internationally recognized identity cards issued to stateless refugees. In 1942, they were honored by governments in 52 countries. Many Jews became stateless before and during the Holocaust, because the Nuremberg laws excluded them from German citizenship. After World War II, the United Nations was set up in 1945, immediately after the end of World War II. From its inception, the UN had to deal with the mass atrocities of the war, including the huge refugee populations across Europe, to address the nationality and legal status of these refugees. The United Nations Economic and Social Council requested that the UN Secretary-General carry out a study of statelessness in 1948. In 1948, the Universal Declaration on Human Rights was adopted. It provided both a right to asylum and a right to nationality. The declaration also expressly prohibited arbitrary deprivation of nationality, which had affected many of the wartime refugees. In 1949, the International Law Commission put nationality, including statelessness, on its list of topics of international law provisionally selected for codification. In 1950, at the behest of ECOSOC, that item was given priority, and ECOSOC appointed an ad hoc committee on refugees and stateless people to draft a convention. A treaty on refugees was prepared with a draft protocol addressing the status of stateless persons. The convention relating to the status of refugees was adopted on the 28th of July 1951. As of January 2005, it had attracted the signatures of 145 state parties. Since the International Refugee Organization, the predecessor to the United Nations High Commissioner for Refugees, was in the process of being dissolved, the convention was adopted without the protocol addressing statelessness. The International Law Commission, at its fifth session in 1953, produced both a draft convention on the elimination of future statelessness and a draft convention on the reduction of future statelessness. ECOSOC approved both drafts. In 1954, the UN adopted the Convention relating to the status of stateless persons. This convention provided a definition of a stateless person and set out a number of rights that stateless persons should enjoy. The convention thus became the basis for an international protection regime for stateless persons. However, in order to ensure that the rights enumerated in the convention are protected, states need to be able to identify stateless individuals. 7 years later, in 1961, only 1 year after the 1954 convention entered into force, the UN adopted the Convention on the Reduction of Statelessness. In 2014, following a series of expert meetings, UNHCR issued a handbook on protection of stateless persons. Stateless refugees covered by the 1951 Convention should be treated in accordance with the international refugee laws. On the 13th of December 1975, the 1961 Convention on the Reduction of Statelessness entered into force. It provides a number of standards regarding acquisition and loss of nationality, including automatic loss renunciation, and deprivation of nationality. In 1974, the UN General Assembly requested that UNHCR undertake the functions established by the Convention on the Reduction of Statelessness. While the convention had only 37 state parties on 1 January 2011, 33 states pledged to accede to it at a ministerial event organized by UNHCR in December 2011. As of 1 September 2015, the number of state parties had increased to 64. Starting in 1994, the UNHCR Executive Committee and the UNGA asked UNHCR to broaden its activities concerning statelessness to include all states. In 1996, UNHCR was asked by the UNGA to actively promote accessions to the 1954 and 1961 conventions, as well as to provide interested states with technical and advisory services pertaining to the preparation and implementation of nationality legislation. An internal evaluation released in 2001 suggested that UNHCR had done little to exercise its mandate on statelessness. Only 2 individuals were tasked with overseeing work in that area at UNHCR headquarters, though some field offices had been trained to address the issue. The evaluation also noted that there was no dedicated budget line. Concerned organizations such as the Open Society Justice Initiative and Refugees International have called for UNHCR to dedicate more human and financial resources to statelessness. In 2006, a statelessness unit was established in Geneva, and staffing has increased both in headquarters and in the field. As part of an overhaul of UNHCR's budget structure in 2010, the budget dedicated to statelessness increased from approximately $12 million in 2009 to $69.5 million in 2015. In addition to regular staff in regional and country offices, UNHCR has regional statelessness offices in Dakar, Senegal, for West Africa, Nairobi, Kenya, for the Horn of Africa, Pretoria, South Africa, for Southern Africa, San Jose, Costa Rica, for the Americas, Bangkok, Thailand, for Asia and the Pacific, Almaty, Kazakhstan, for Central Asia, Brussels, Belgique for Europe, and Amman, Jordan, for the Middle East and North Africa. In 2004, EXCOM instructed UNHCR to pay particular attention to situations of protracted statelessness and to explore, in cooperation with states, measures that would ameliorate and end these situations. In 2006, it provided UNHCR with more specific guidance on how to implement its mandate. The conclusion on identification, prevention and reduction of statelessness and protection of stateless persons requires UNHCR to work with governments, other UN agencies, and civil society to address statelessness. UNHCR's activities are currently categorized as identification, prevention, reduction, and protection. UNHCR has achieved some success with campaigns to prevent and reduce statelessness among peoples in the Crimean Peninsula who were deported en masse at the close of World War II. Another success has been the naturalization of Tajik refugees in Kyrgyzstan, as well as campaigns that have enabled 300,000 Tamils to acquire Sri Lankan citizenship. UNHCR also helped the Czech Republic reduce the large number of stateless persons created when it separated from Slovakia. At the beginning of 2006, the UNHCR reported that it had records of 2.4 million stateless persons, and estimated that there were 11 million worldwide. By the end of 2014, UNHCR had identified close to 3.5 million stateless persons in 77 countries and estimated the total number worldwide to be more than 10 million. UNHCR does not report refugee populations in its statelessness statistics in order to avoid double counting, which would affect the total number of persons of concern. Stateless refugees are counted as refugees, not as stateless. For the same reason, Palestinian refugees under the mandate of the United Nations Relief and Works Agency for Palestine refugees in the Near East are not reported in the UNHCR statelessness table. Instead, they are referred to elsewhere in UNHCR's statistical reporting. While the two UN Conventions on Statelessness constitute the primary international framework for the protection of stateless persons and the reduction of statelessness, there are also regional instruments of great importance. The 1997 European Convention on Nationality, for example, has contributed to protecting the rights of stateless persons and provides standards for reducing statelessness in the Council of Europe region. That document emphasizes the need of every person to have a nationality, and seeks to clarify the rights and responsibilities of states in ensuring individual access to a nationality. Statelessness of some magnitude exists in every country of the world. Today, some of the largest populations of stateless persons are found in Algeria, Bangladesh, Bhutan, Cambodia, Côte d'Ivoire, Democratic Republic of the Congo, Dominican Republic, Estonia, Iraq, India, Kenya, Kuwait, Lebanon, Malaysia, Mauritania, Myanmar, Nepal, Saudi Arabia, Syria, and Thailand.